Mr. Dane Hamilton Q.C., you were the legal representative for the applicants.
Yes.
Tell me, how do you feel about the judge's decision?
Well, I must say that I feel very satisfied in a very important sense that the judgment established the principle that you cannot take people's names off of the register of voters unless you follow the proper procedure. And that is in essence what our applications were. We were faced with a lot of time constraints, and we would have liked to have itemized the applications, both applications, so that it would encompass the 243 voters, but time did not permit it. It was an undertaking that required far more than the 2 days within which we filed our application. I must say that I am horrified that, having listened to the arguments and the evidence that was presented in the case, that the supervisor of election did not ensure that a revised monthly list was published as mandated by law, so that persons who are directly affected by the action of the registration officers could have made adequate representations in the courthouse.
Now tell me, you were just seeking leave for a judicial review?
The essence of our challenge was that it was not a constitutional action, it was an application for judicial review of the decision of the registration officer. Now, when one files, and one must first apply for leave to file judicial review proceedings, and we are entitled to ask, once we make that application, for interim remedies, interim relief. And the relief which we sought was that to have the names of the affected persons restored to the register. There were two cases. One was brought by the leader of the opposition, and he brought it on behalf of all of the persons who were removed from the register. The judge ruled that he did not have a sufficient interest, in that he did not purport to have brought the proceedings on behalf of the party. All he said is that he was the leader of the party. There's nothing to show that that he was really acting on behalf of the party. But that is the judge's decision, and I respect it. And on that basis, the judge disallowed his application. But the other application, which was brought by the Palmer's Velospin, I call it the Palmer's Velospin application, the judge actually granted leave to apply for judicial review and made the order based on the evidence which was before him in court, that these persons must be forthwith restored to the voters list so that they can vote on the 11th of July 2011.
So what would be they've already been restored to the list. Would it be necessary to still proceed with the judicial review, and what would be the difference?
Well, that is a decision that we will take in the ensuing week. Of course, we have some time within which to file a claim for judicial review. And you see, Caribbean people have very short memories. And like I said in court, is that we need to stop this type of behavior now. Otherwise, each and every one of these islands would have parties in power who attempt to do the same thing. I make no bones about that. I may have no apologies to make about it, but I think it is very critical, given this juncture in the life of the Caribbean, that we ensure that the people in each and every one of these democracies get a free, fair and impartial election in which they all have the right to participate in choosing their representatives in Parliament.
I was asking, what would be the difference with the judicial review?
Oh, well, the judicial review would only formalize the decision, assuming, of course, if we go to court, we win the case, but I'm pretty certain that we will win the case. Because the actions of the registration officer was wrong. It was manifestly wrong and unlawful.
I wanted to ask you about that. Now, if this is a matter of procedure, couldn't this have been picked up and rectified before going to court?
Well, you must bear in mind that one of the contentions we made was that the chief elections officer was not publishing the revised monthly list. So you're taking people names off of the electoral list willy-nilly, and you're not giving them adequate notice that their names have been so taken off. If he was publishing the revised monthly list, quite naturally we would have been able to pick up on the fact that their names are not on the list.
But if I go to the electoral office, I say, I received my notice on the 19th, but it says my hearing was on the 12th, and therefore I did not know about it, I wasn't able to attend and represent myself, but my name was still taken off. Couldn't the electoral office at that point have dealt with it before it got as far as the court?
Well, you were in court as if I remember quite rightly, and we did raise the issue in relation to the Palmer. I think her name is Agnes Palmer, said she went to the electoral office and they said there is nothing they can do about it.
But is that in fact so?
No.
I don't know all the rules and regulations and the act inside out, but is that in fact so? Because we've seen in the court that things have happened that ought not to have happened, so maybe that's something they could have dealt with and they didn't, so I'm asking.
That serves to remind us that in these political games, the capacity of the human being to be disingenuous is always a factor. And what the judgment is seeking to do is to remove that sort of disingenuity from the process. There is a process laid down in the law and we must all follow it.
I think this might be my final question. Now, there's been some issue with regards to the chain of command between the Electoral Commission, the Supervisor of Elections, and the registration officers. It's understood that the registration officers have quasi-judicial functions, but with regards to the notices, some lawyers have argued that those are administrative procedures, and that the Supervisor of Elections could have intervened in that regard. Is that actually so, or how should it be?
Well, obviously the Electoral Commission can give directions to the Supervisor of Elections, and the Supervisor of Elections can give proper directions to the registration officers. And he did do so in the case of David, a matter that occurred in March of 2010, where the very same issues that the applicants in this case complained of surfaced, and he gave directions that they must follow the proper procedure. So one have to ask oneself if what is good for Peter is not good for Paul, and how can he be so disingenuous in saying that he's not bound to accept the directions of the Electoral Commission to do what is right? There is no gray area. There's right and there's wrong in these matters. And we as a Caribbean people must stand up for the right, not the wrong. And anybody who say otherwise, I'd say to them, they want us to head down the path of destruction and petty despotism.
But I don't have any more questions. I don't know if there's anything you'd like to add that I've not covered.
No, I think the judgment has vindicated our position. The judgment of Mr. Justice Mario Michel vindicated our position, and I would ask that the people bear in mind that the list was only published on last Saturday, July the 2nd, and we had very little time in which to bring this case, and we have done better than expected in the circumstances.
Well, thank you so much, Mr. Dane Hamilton Q.C., legal representative for the Concerned Citizens Movement.
Thank you very much.